The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the Kansas Supreme Court. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the docket for 11 o'clock.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Friday, May 28th, 2021 consists of one case. Appeal number 121866, State of Kansas versus Luqman Keys, Shawnee County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. I do want to pause for a minute just to note that we do have Chief Judge Johnson's sitting with us today. Justice Wilson is recused on this case and he is sitting in her position. Chief Judge Johnson has served since January of 2013 as a district court judge in the 20th Judicial District. The 20th is a 5-county district in Kansas. I've already mentioned Barton County is one of those counties. Ellsworth, Rice, Russell, and Stafford make up the remainder of that district. Chief Judge Johnson has served in the position of Chief Judge just since January of this year. He joins us in that administrative position at a very challenging time. So we're fortunate to have him there, as well as fortunate to have him taking time away from those responsibilities and his busy docket to help us today. Judge Johnson, we're honored to have you join us and we thank you for your assistance.
Thank you.
Counsel, Judge Johnson, along with the rest of us, have read your briefs and look forward to your arguments. Judge Johnson will participate in the court's deliberation after the oral argument and continue working with us through the resolution of the appeal. At this time, then, I would ask the attorneys to please state your appearances.
May it please the court, Kai Mann of the Appellate Defender Office, here on behalf of the appellant, Luqman Keys, ready and present for argument.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers and present ready for argument.
Thank you, counsel. Mr. Mann, you may begin.
Thank you, Your Honor. At trial, Luqman Keys testified that Cole Gilbert and Arden Keene solicited him to purchase marijuana from Mr. Gilbert. After being invited into Mr. Gilbert's apartment to complete the transaction, Mr. Keene attacked Mr. Keys, who shot in self-defense, killing Mr. Keene. The jury was instructed on felony murder with aggravated robbery and aggravated burglary underlying the felony murder as well as individual counts. The jury was also instructed on self-defense and found Mr. Keys not guilty of aggravated burglary, but hung on felony murder and aggravated robbery. Having failed to prove its case to a jury, the state obtained a second superseding indictment, adding distributing or possession with intent to distribute a controlled substance as an additional inherently dangerous felony. Mr. Keys' testimony was read into evidence at the second trial, and the district court refused to instruct on self-defense. The jury then convicted Mr. Keys on both felony murder and aggravated robbery, and this is Mr. Keys' direct appeal. Before diving into the issues in depth, it is important to note that this court has previously observed that the essential task for the appellate courts in the criminal context is to discern which proceedings are so imperfect that they are unfair, and these were such proceedings. One of the primary reasons for the unfairness was the fact that Mr. Keys proceeded to trial on a fatally defective indictment. The second superseding indictment, fatally defective, depending on how many prosecutions there were.
Mr. Mann, I hate to interrupt you so early, but I want to understand what is the difference between an amended indictment on one hand and a superseding indictment on the other, if there is a difference?
I think that to the extent that there is a difference, and first it should be noted that there really is no Kansas case law or statute that even allows the state to seek a superseding indictment. And where I would draw a distinction between an amended indictment and a superseding indictment is that a superseding indictment adds a completely new crime that could have been added before and then can be joined pursuant to that statute. And so instead of having, multiple prosecutions, basically joinder. Now, where the state in this case has added a new theory of an already charged crime, then that just in turn becomes an amendment, and that's plainly prohibited by KSA 203015 or 2230.
So you wouldn't say the difference between the two is that an amended indictment under 223015 doesn't go back to a grand jury, but a superseding indictment does go back to a grand jury, right?
Yeah, correct.
And then would you agree that when there's a superseding indictment that the original indictment still stands?
I don't know. And again, there is no Kansas law in this situation. And so whatever this answer is probably going to be answered by this court in this case.
But is there United States Supreme Court law on that issue? I found that there was, or my research attorney found that there was, that the United States Supreme Court has said that they both stand.
And that is fine when you're dealing with the United States Supreme, or when you're dealing within the federal procedure. We're not in the federal courts, we're in the courts of this state. And in this state, we have no mechanism or case law that seems to allow for this. And furthermore, when we get into the arguments we made in the SIR response brief, the difference between this is largely how the different courts are set up. In the federal courts, you can only charge felonies via indictment. Whereas in Kansas, we have the indictment, the information, and the complaint. And
is there a statute in the federal system that allows for superseding indictment specifically?
If there is, I was not able to locate one. This appears
just like in Kansas, there's not, right?
Right, but where we are different is that in Kansas, we have the information and the complaint that allows for amendments at any time up until the time goes to the jury, whereas we have indictments where there is no amendment permissible unless they do not go to the substance or the
which goes back to my question about, it seemed to me that your argument conflated the amended and superseding indictment, those two different procedures.
And again, I would still go back to the issue that in Kansas there has been no distinction. We don't have this case law, and anything else would just be shoehorning federal procedure in, and the federal rules of criminal procedure just don't act as gap fillers. That we're in two totally different systems here. And furthermore, the Kansas statutes seem to indicate that every time an indictment is filed, a new prosecution has begun, which before jeopardy attaches really isn't a problem. But after jeopardy attaches, now we have two indictments representing two prosecutions that jeopardy has attached to. How is this not a double jeopardy problem? And furthermore, I think that, depending on whether or not you view this as one prosecution or two prosecutions, we have error that renders this indictment fatally defective. And so depending on how many prosecutions there are, that doesn't make the second superseding indictment proper. It just makes the reasons for why it's fatally defective different. And I do think that under our current statutory process, that either way, this is incorrect. And the state.
Let me just take one step back. As you noted that you brought up the double jeopardy issue for the first time in your reply brief. Why is that properly before us?
A few things. One, it goes to a constitutional issue that should be able to be raised at any time. Furthermore, I don't think that the motion to dismiss, when they had that hearing on the motion to dismiss and for a racially selective prosecution and the motion to
let me just correct you, or not correct you, ask you. I didn't find any motion to dismiss in the record.
There is a motion to dismiss pursuant to 3208 subsection 3 dealing with the racially.
Oh, sorry. Okay,
Yes.
I thought you meant a motion to dismiss the
No,
indictment.
but there was a motion to disallow his testimony from coming into the second trial. But when you read the transcript of that hearing, that whole issue is based off of the fact that Mr. Keyes didn't have notice of the theory that the state was going to proceed at the second trial. So the issue of notice was always before this court. And furthermore, the fact that we have a double jeopardy violation here, that's an exception to an issue for the first time on appeal. And honestly,
But isn't that your due process? That's not, that's your due process claim.
I think it's both. I think it is both a double jeopardy violation and denies him due process.
And I understand that you're making both arguments, but it seems again as if you're conflating. I was talking about preservation on the double jeopardy.
Sure. And again, given that we're dealing with fundamental rights and it is the imperative function of this court to root out which proceedings are unfair, I think this court has the discretion to reach the issue. And furthermore, I think that this court has also said that preservation issues are not jurisdictional, they're prudential. And when we're dealing with violations of fundamental constitutional rights, I think before any court decides not to reach an issue, there has to be a reason identified to not. And to put this in even better perspective, here we are in a situation to where Mr. Keyes goes through a trial. The state switches up their theory at a point in the litigation where he can't defend himself from the new theory. And I'm arguing this on an issue that's never really been raised before this court before with the indictments. The state comes up with their argument that exposes a double jeopardy issue. And so then I follow that. Essentially, if what the state did at trial is proper, then I don't see how my evolution of this issue on appeal could be improper. If anything,
did the state ever, since you brought it up in your reply, did the state ever have an opportunity to address it before?
They did. They filed their surreply brief, and when they filed that motion for surreply, I specifically did not object to that response because I felt that is something that they should also get a chance to respond to, unlike Mr. Keyes at trial. So I mean, it's one of those, and to be honest, when we talk about preservation as an appellate attorney, it kind of inflicts a little bit of existential angst in me, because if I am limited to only what is argued below and only within those exact parameters of what's argued below, I don't know what my role is. And I don't even know what the role of appellate litigation is, because if that is all that is allowed to be talked about on appeal, it would almost make more sense to have the court just read the record and tell us what's reversible and not. So I think that, given that preservation is a prudential consideration, that unless this court finds a good reason not to reach an issue, defending the Constitution requires this court to reach the issue, or else we just ends up in judicial abdication. And so that's how I view preservation and how that should go. And even more fundamentally, that even if this superseding indictment was correct and we have no constitution or statutory violation, I think that this case still needs to be reversed based on the fact that Mr. Keyes' primary defense in this case of self-defense was completely cut off at the knees at the second trial, despite no evidence that would touch on the subject of self-defense changing between the first trial and the second trial. I know.
Why, Mr. Mann, why would it have been factually appropriate to give that when he testified in the first trial that he was not in fear of death or great bodily harm?
I believe he did testify that he was in fear of great bodily harm. I believe that did come out within his testimony, and that he was simply reacting to. And furthermore, I think that even kind of exposes where we get into the issues of why imperfect self-defense should be covered under that self-defense umbrella, because even if Mr. Keyes' testimony, the jury finds that does not support perfect self-defense, which I believe it could, I believe that the jury could easily find that we have either an excessive force situation or an honest but unreasonable belief justifying either a voluntary manslaughter or an involuntary manslaughter conviction. And so I think that once this court understands that imperfect self-defense fits naturally under the umbrella of self-defense, which, as I note in my brief, is a constitutionally protected defense, that given the situation, it is certainly factually appropriate to instruct on all three of those, give all three of those instructions to the jury. And if that was done, then I don't think we're here arguing about felony murder. I think we're arguing about some other crime, or maybe we're arguing, simply about nothing. Maybe Mr. Keyes gets totally acquitted. I mean, we got to remember, this took the state two jury trials to get these convictions. This evidence is not incredibly strong. And so that is just where I think that, the bulk of the prejudice lies. And I see that I'm out of time. I'm happy to answer any questions or sum up. May I have a brief moment to sum?
You may. You may.
Thank you, Your Honor. The state's actions following the first trial relating to selective prosecution and the second superseding indictment and the district court's self-defense rulings at the second trial were incredibly unfair and demand reversal of those convictions. Luqman Keyes deserves better. The citizens of Kansas deserve better. The Kansas Constitution, the federal Constitution, and notions of procedural fairness require better. Thank you.
Ms. Chalmers?
May it please the court, the state plans on addressing both the superseding indictment issue and the jury instruction issue if there is time. As to the superseding indictment issue, it is the state's position this issue should not be addressed at all. There was no motion to dismiss filed based on the fact that the state has no authority to do a superseding indictment. The double jeopardy claim was first raised in a reply brief. The state did have the opportunity to do a reply brief where the state argued that the issue was not properly in front of this court. And then the defendant was given an opportunity to brief yet another evolution of this issue, and the state was not given the opportunity to respond. If the state simply agrees with Justice Standridge, a superseding indictment is not an amended indictment. The statute bars amendment indictments, not superseding indictments. There's nothing in the federal rules that permit a superseding indictment, but it is longstanding and well-known practice. I did make a mistake in my brief. Rule 7E parallels our amended information statute or complaint statute, not the indictment statute that we have. But if you do reach this issue, again, I think it's very clear that the state should be able to get a superseding indictment. I think the more interesting question is the double jeopardy question and whether or not a superseding indictment can happen after a jury trial. The defendant spends a lot of time complaining that the state somehow sneak attacked him. It was not the state's anticipation that there would be a hung jury. We didn't know that he was distributing marijuana until he got on the stand and confessed to that. That's not the state's fault. He chose to waive his Fifth Amendment right, and he chose to confess to distribution of marijuana in hopes of getting out of a criminal conviction. His jury then hung. And at that point, we're in one ongoing prosecution, and the state is unaware of any constitutional bar. And Mr. Keyes certainly doesn't point to any case law providing a constitutional bar to getting a superseding indictment. In fact, some of his own citations support that. Just to briefly respond, since I didn't get to his argument, when he cites to CJS section 54, that's relying on a New York statute that the Kansas does not have the equivalent of. We have no mistrial statute saying that charges can't be modified after mistrial is declared. CJS section 225 cites to a case that doesn't support what the CJS is saying. Essentially, that case allowed a trial on any of two indictments after a mistrial. They had tried on one indictment. There was a mistrial. They went back and tried on the other indictment. And what the court said was, okay, yes, you can do that, but the fact that you got a conviction essentially is an acquittal on the other indictment. You can't just keep trying these indictments once you get a conviction. Regardless, even if you can find error here and you want to reach the issue, and it should be harmless. The aggravated robbery conviction or charge was the same on both. The jury convicted of aggravated robbery. And under that, we didn't need the distribution of marijuana anymore. And again, he had all the notice he was constitutionally required to, and we amended his indictment a few months before his second trial. I had one other thing I thought I wanted to say. No, I'm good. Can't find it. It's moving to self-defense instructions issue. Again, all of his constitutional claims are raised for the first time on appeal, and I don't think should be considered by this court. Starting with self-defense, what he wants to do is essentially rewrite years of this court's case law and say that distribution of a drug is not a dangerous felony that counts under the felony murder statute. The state just disagrees with that. But regardless, you can avoid this entire issue, again, because of that aggravated robbery conviction. The jury convicted him of aggravated robbery. By doing so, it necessarily found that his trial testimony was not credible. They could not have done an aggravated robbery conviction and found that he walked into that room and was attacked, and then just apparently after being attacked and killing someone in self-defense, just grabbed some stuff on the way out for the fun of it.
Ms. Chalmers, could you explain it, or maybe clarify what the trial court's ruling was on self-defense in the second trial? Apparently denied the requested instruction, but then said you can argue it, made some reference that you can go ahead and argue self-defense. So what is the point of going ahead and arguing a theory that you have no legal instruction for? I mean, why can you argue, allows to argue, what's the point of that?
I would agree that it is probably not a particularly useful thing to argue something when there's no case law given it. It's essentially allowing a nullification type argument. If there's no self-defense available, they're arguing.
Well, am I correct? That's what the trial court said.
I don't.
Looking at the record, it's made some kind of reference to, I'm not going to give the instruction, but you can go ahead and argue self-defense. And help me understand why that's permissible.
I genuinely don't remember that. I don't remember there being, I don't remember that. And no, I agree that the court's ruling would have been erroneous. If there's no legal right to self-defense, then they shouldn't have been able to argue about self-defense at all. To the extent the court was just being overly generous and saying, well, if you want to toss self-defense out there and see if the jury bites on that, it's not something I agree with, but I can't see how it harmed the defendant. I don't think the defendant here was entitled to self-defense because he did admit to the distribution of marijuana. So there's no controverted fact. Under this court's case law, if there's a factual issue about whether or not there is a self-defense instruction, the felony is being committed, then yes, he does get self-defense. I would like to take a little bit of issue, not with the case that says that if it's charged, you don't get self-defense. I agree with that. Just because we charge something should not preclude the ability for to commit self-defense. But if you have a jury that is instructed that the only way that you can commit felony murder is if you are committing the felony, then you don't really need all the self-defense stuff, because if the jury doesn't think they're committing the felony, they would just acquit because there's no felony murder. They didn't commit the felony. Here we know they thought he committed the aggravated felony because he was found guilty of that aggravated felony. As to the constitutional claim of self-defense, self-defense is not an absolute right. There's no, any more than Mr. Keyes had the right to possess a firearm. He didn't. He had committed an aggravated robbery prior and he had lost that right. While self-defense has constitutional protections, the state doesn't dispute that in any way, shape, or form. It doesn't give a person who's committing a forcible felony or a violent felony, or maybe even a felony at all, any right to defend themselves. Holding otherwise would effectively hold that a person can basically break into your home armed, commit a burglary, and if you attempt to defend yourself, they can shoot you.
Are you basically saying, counsel, that in this kind of circumstance, when a jury finds a defendant guilty of the underlying felony, that as a matter of law, any failure to give self-defense instructions is harmless?
Yes.
Okay.
I'm not sure that there might be facts that somehow make that different, but here, yes, it is harmless. And it should be in all the cases I can think of, sorry.
What would those facts be?
I can't think of any. If the defendant is convicted of the underlying felony that barred his ability to have self-defense in the first place, I can't imagine how it'd be anything other than harmless. but creative arguments might exist that I'm just not thinking of. As to the imperfect self-defense claims, I just don't even follow the argument how imperfect self-defense suddenly becomes a constitutional right. I don't know of any constitutional requirement that imperfect self-defense exists in the first place, much less is the equivalent of self-defense. Imperfect self-defense is not a defense at all. Even Kirkpatrick, the case cited by the defendant, says as much. I think the state could entirely abolish imperfect self-defense crimes without any constitutional issue. For that reason, there's no reason for this court to overturn its decision in Love. There are no right to lessers and felony murder. And in general, the mere invocation of HODIs without any sound rationale as to how it applies should be shut down by this court. Unless there are further questions, the state would respectfully request that you affirm Mr. Keyes' convictions in this case.
Any other questions? Mr. Mann, you reserve 3 minutes. You're still muted, Mr. Mann.
Excuse me, Your Honor. Thank you. On rebuttal, I want to go back to this point that the state brought up about the aggravated robbery conviction and how this somehow absolves the self-defense issue. It does not. And to show that, I would ask this court to take a good look at the aggravated robbery instructions. The jury was instructed that the taking was by threat of bodily harm, and that Mr. Keyes was either armed with a dangerous weapon or inflicted bodily harm. Now, given this court's prior precedent that a robbery can be effectuated after the application of force or the death, in this case, the jury could easily find that Mr. Keyes' legally justified act of self-defense provided an implied threat to Mr. Gilbert to prevent him from intervening when Mr. Keyes allegedly took the marijuana from the table. Therefore, it is completely possible for the jury to find him both guilty of aggravated robbery, considering he was armed, as well as not guilty of felony murder based on self-defense.
But counsel, help me think through that. You're making a fact-based argument, but as I understand the state's making a legal argument that self-defense is simply not legally available to somebody who commits an ag robbery.
And again, I think that in this situation, the ag robbery is not contemporaneous, or the killing was not contemporaneous with that aggravated robbery. It was not done in the commission of the aggravated robbery because the aggravated robbery hadn't started yet. And it wasn't done with the flight or the attempt of the aggravated robbery. So in this situation, the felony murder and the aggravated robbery are actually separate things. And the jury, and again, we're back to constitutional defense. It's up to the state to prove that the lack of this instruction would not have mattered. I think the first trial plainly refutes that. We have a jury given that instruction who finds him guilty on both. And in fact, I think that once self-defense is actually given to the jury, it actually shades the tenor of the whole robbery. And again, this is the state's burden to prove that the trial would not be different. And I don't think that there is any way under this record, under a fair reading of this record, that we can come to that conclusion simply because the jury got instructed on self-defense and they found him not guilty of the robbery and the felony murder. And both of those instructions are legally proper. Again, as we go through the brief, the state, notes that I'm trying to overturn, like 25 years of case law. Well, the 25 years before that, the interpretation of 215111N was actually correct. It's not until Mitchell where we get the erroneous interpretation, and Mitchell is carried forward, and Mitchell and its progeny need to be overruled. And for those reasons, as well as those included in the brief, I would respectfully request that this court vacate Mr. Keyes' convictions because these proceedings were unfair. Thank you.
Are there any other questions for counsel? Okay, to thank both counsel for your arguments this morning. The court will take this appeal under advisement. We are now in recess until 1:30 this afternoon.